Our speaker today is Dr. Felix Wu. Dr. Wu is the faculty director of the Cardozo Data Law Initiative. Professor Wu's teaching and research focus on privacy, freedom of expression, and information law. Drawing from his dual degrees, JD and PhD in computer science. And now we will continue on with our presentation. So let's learn from Dr. Wu.
Great, thank you, Val, for that introduction. As Val said, my name is Felix Wu. I'm a professor at Cardozo Law School, also director of our Cardozo Data Law Initiative. And today we're going to talk a bit about data breach notification law. And to do that, we'll start by looking at what happened to Uber. So you may have heard of this story, but just in case you haven't, just try to describe what happened to Uber over the last year or so. So in November of 2016, someone going by the name of John Does, that's D-O-U-G-H-S, John Does, sent an email to Uber's security team saying that he had found a major vulnerability in their systems. And in particular, it appeared that some of the digital keys that they were using were being stored in a place that was publicly accessible. And that using these keys, you could then access Uber's cloud storage systems, where John Does was then able to find account records for 57 million drivers and riders of Uber. So he approached Uber with this, and Uber then was largely treating this as a kind of security report. They had an existing kind of bug bounty program by which they would encourage people to report security incidences to them. But in this particular case, the hacker who is engaged in this hack, John Does, said that he wouldn't accept less than 6 figures. And in the end, Uber decided to, in fact, pay him $100,000 in return for his agreement to delete all of the data that he had downloaded, which Uber then at least attempted to verify by being able to get a copy of the hacker system, basically, to be able to see that the data had been deleted. And so Uber then treated this as a kind of resolved issue. This was, again, back in late 2016. But then the incident came to light at the end of last year, at the end of 2017, almost a year after the contact with John Does. And then the question became whether or not Uber had violated any laws by failing to disclose this hack to their customers and to other authorities for that year plus in which it had happened. So what we're going to explore a little bit today is what the legal requirements are around this kind of the need to disclose these kinds of data breaches. And I should say at the outset that we're going to explore the law here, but of course there are lots of reasons why companies might want to, in fact, disclose these sorts of things, even apart from what the law might or might not require. On the one hand, it might simply be, as Uber's now said, the right thing to do, the ethical thing to do. And for that matter, it might in fact be the better position as far as public relations is concerned, because clearly Uber is faring much worse in a kind of PR sense from having had this disclosed much later. It's been described by many people as a kind of cover-up or something of the sort, than I think would have been the case had they disclosed it earlier. But what we're going to look at is what the laws actually require, and the relevant laws are these data breach notification laws. These laws are primarily state laws, and indeed almost every state plus DC and the various territories has one, the only 2 exceptions currently being Alabama and South Dakota. These laws are not that old in some sense. I guess it depends on your view of what counts as old in kind of the internet era or the like. But the first of these became effective in California in 2003. Though since then, many states, as you see, have then followed California's lead in adopting these kinds of data breach notification laws. But despite them having followed this lead, the states have then diverged quite a bit in terms of the content of these laws, and that's a bit about what we're going to end up talking about today. And so the effect is that there's actually quite a bit of variation among these kinds of laws in the various states. So as I described, these laws are primarily state laws, and at least with respect to most data breaches, it's really state law that applies. There is a federal law that covers health information in particular, but there's no federal law covering just data breaches broadly speaking. There have been various attempts over the years to try to enact such a uniform federal law, but so far they have not gone anywhere. And so the result is that companies need to look at all of these various state laws to try to determine what indeed they potentially need to do in case there is a data breach. So what I'll describe a bit about today is to think about the variety of these different kinds of data breach laws, and perhaps also to explain a little bit about why, in a case like Uber, on the one hand, maybe it seems obvious that they should have disclosed it, or that the law should require them to disclose it. But in fact, the laws are a bit all over the place in the sense that they cover, in some ways, maybe less than one might expect, and maybe more than one might expect at the same time. So I've tried to describe a little bit about the different ways in which that might be the case. So in order to do that, we're going to talk about basically four things. What kinds of things are covered by these laws? If a data breach is covered, when do you have to actually disclose? To whom do you disclose? And how do you go about disclosing? But most of it really is the first one. It's the question of what counts as a data breach that you'd actually have to disclose in the first place. So here, for example, is New York's data breach notification law. It says that any person or business which conducts business in New York State shall disclose any breach of the security of the system following discovery or notification of the breach to any resident of New York State whose private information was or is reasonably believed to have been acquired by a person without valid authorization. All right, so it describes this idea of there being a breach that results in private information having been acquired without authorization, and that's what it is you potentially have to disclose. Okay, but one key question here is what counts as private information that's covered under a statute like this? So, for example, if we leave Uber to one side for a minute, suppose you've got a website that's largely dedicated to online dating of married people, so essentially affairs of various kinds. And suppose someone hacks the system and then is able to obtain the customer list of such a website, right? So you've got names, let's suppose names, addresses, identities, or whatever of the people who have actually registered for this particular website. Does that count as a breach that's going to require notification under these statutes? Or suppose you've got an internet-enabled webcam, right? So the idea here is that you set up one of these webcams in your home, and what you can do is you can turn it on or off remotely, right? So that you can then check up on your pets or your kids or whoever else might be in your house. Even when you're away, there was a security flaw that then made it possible for any member of the public, essentially, to go view other people's webcams even without actually logging in to their account, right? So this seems incredibly invasive. People, essentially strangers, are now able to just look into your house. Is this the kind of thing that's going to require some sort of notification? And indeed, most of the time, the answer to those questions in both of those cases is actually no. So that even though the statute talks about private information, it defines private information in a very specific way. Indeed, it defines it as some kind of identifier, something like a name or other way of identifying a person, plus either a social security number, a driver's license number, or an account number like a credit card number or the like, right? And so this was what counts as private information, the acquisition of which needs to be disclosed under New York law, for example. What I'm showing you here is the definition for New York law. So in a case like the Ashley Madison case, where you've got some very sensitive information, that's not the kind of thing that would be required to be disclosed in New York, because the hackers there, obtained essentially just names, right? Now, what was sensitive about it was that these names corresponded to people who had set up profiles on this website where they didn't want people to know about it. But no social security number, driver's license number, or credit card number was necessarily acquired, or at least in the hypothetical I'm describing, that nothing was necessarily acquired of that sort. And so then the data breach law wouldn't apply. Same thing with the TrendNet example that I showed you. being able to see into someone's house is incredibly invasive, but it's not the same thing as acquiring someone's social security number, driver's license number, or credit card number. So as you can see, a lot of these data breach notification laws are specifically targeted really at the problem of fraud or identity theft or something of the like, right? These are all things you could use to commit fraud and identity theft pretty much. And it's the acquisition of those kinds of information that the data breach notification laws are primarily targeted at. Now, some of them are broader than New York's law. So here, for example, is Wyoming's List, which I think is one of the longest of the lists, at least if you sort of, in terms of the number of individual items in the list here. Barely fits on the slide as I was putting this together. And so here we've got some of the same things: social security number, driver's license number, account number, and the like. But Wyoming was thought about it even a little bit more broadly than that. And included things like shared secrets or security tokens, as well as things like a username or email address in combination with a password or security question and answer that would permit access to an online account, right? A lot of times, if you want to be able to do something like access someone's bank account, you wouldn't necessarily need their bank account number or anything like a social security number, driver's license number, if what you had was their actual username and password for that account, right? So this is designed to cover those kinds of situations, the ability to commit fraud with things like usernames and passwords, and not just with something like an account number or a credit card number. And also, if you look down toward the bottom, it also covers unique biometric data. And the idea here, too, was the possibility that if you acquired biometric data, you could also use that to fool some kind of system into thinking that you were someone else and thereby access their accounts or something of the sort. Wyoming's law, like a few other states, but unlike New York, also separately covers medical information and health insurance information. This is some of the information that's also potentially covered at the federal level, and then various kinds of states also do this. Now, this is a little bit different because here I think the concern really is just over this kind of information being particularly sensitive. Although there also have been instances of various kinds of medical fraud that I think this is also designed to combat. So it's probably some combination both of combating fraud and wanting to prevent the access to this kind of particularly sensitive sorts of information. All right, but even in that broadest list of categories, many of the other things that I showed you, like the Ashley Madison or TrendNet examples, don't seem to raise anything even under that broader list. In the Uber case, though, there was something in the list, even in the shorter list, and that was because Uber has drivers, and so then even if you couldn't necessarily get at people's financial information, part of what was being stored in these account profiles was the driver's license numbers for all of these Uber drivers, right? That's part of what they collect as signing in terms of signing up drivers. And so that means that the information that was acquired in the Uber hack would clearly be private information under New York law and pretty much under every one of these data breach laws, because this is kind of the core set of things that starts off being the core list that almost every state has, to which some states then add more, but basically no state sort of takes away from this first part of the list. Now Uber itself basically tried to characterize this as, in some sense, no big deal, suggesting that, well, driver's license numbers ultimately are not as useful for committing identity theft as social security numbers or account numbers or credit card numbers or the like. But however they might have thought about it generally, however one might think about driver's license numbers generally, it's certainly the case that they are included in these laws, even if it might be the case that they're a little less useful for committing fraud or identity theft than some of the other things that are mentioned in the list. So that's what counts as private information. But the other main thing that you need in order for there to be a data breach that triggers a notification requirement is, well, a breach, right? It has to be not just some kind of acquisition of private information, but it has to involve some kind of breach of security. And here too, you can have different ideas about what counts as a breach of security. And one might have different ideas before you actually look at any of these laws about which things really count as a breach and which things don't. But the laws themselves are generally quite clear about this. And this too is a term that the various kinds of laws will define, but like in the case of private information, that they'll define differently, and sometimes actually very, very differently in terms of what counts as a breach of the security of the system. So New York says any kind of unauthorized acquisition that compromises the security, confidentiality, or integrity of personal information maintained by a business. One thing I'll note here is that it lists security, confidentiality, or integrity here, and one of the things that often happens in the security realm, at least among, let's say, lay people who are not in the security business, is that we tend to focus a lot on confidentiality, on private information being obtained, and sometimes not as much on integrity, on the idea of the private information still being maintained properly in its original form, right? So the idea here is that if you download information, but you don't particularly look at it or make use of it, but what you've done is to somehow delete the original, right? Then that potentially harms the integrity of the original. It harms, obviously, the business of whoever business this is, even if you end up never reading it, or even if you end up deleting the copy that you've downloaded or something of that sort. That could be a problem of integrity. Okay, but we still need to figure out then what counts then as an acquisition of this data under the law. And here's why this is sometimes hard, right? One common scenario involves something like a laptop theft. So you have some company that ends up storing this kind of private information on some laptop, right? Usually some kind of company laptop that some company employee has been issued, and or maybe even just they themselves managed to download some sort of private information onto their company issued laptop. Now, what happens when that company laptop gets stolen? And what's a little bit tricky about this is oftentimes laptop gets stolen for reasons that have nothing to do with the information on them, right? A nice enough laptop is just a good target for theft. You leave a window open in your car and somebody grabs the laptop out of it. They're probably not thinking about the data on it. They're probably just thinking about the value of the laptop on the black market itself. But on the other hand, it does seem like now all of this private information is potentially in the hands of some third party who, depending on their purposes, might or might not be able to make some sort of nefarious use of it. So oftentimes the law then needs to deal with that kind of situation. And in New York, for example, New York then lists a set of factors that you can consider to try to figure out whether or not something counts as a breach of the system. One of which includes whether or not physical possession and control has been obtained, such as a lost or stolen computer or other device containing the information. So in New York, at least, this kind of scenario is at least a factor to consider, but it's not necessarily dispositive one way or another when you've got that kind of stolen laptop scenario. Other times, other scenarios are probably a little bit clearer, like when the information itself has been downloaded or copied, probably most of the time. That is going to count as an unlawful acquisition, because then if it's the information itself that's been acquired rather than just the laptop on which it was sitting, then presumably whoever went and downloaded that meant to get at the information itself rather than merely getting at the hardware. And then certainly if there's any indication that someone's used it or started to use it for fraudulent purposes, like identity theft or the like, that's number 3 here, then you could be pretty sure then that we've got some kind of unauthorized acquisition under the statute. So that's New York, but there's actually other states in which what counts as a breach is actually quite a bit narrower than what I just showed you under New York law. So here's Virginia, for example. Now it starts off saying something pretty similar to New York: unauthorized access and acquisition of unencrypted and unredacted computerized data, right? But then it adds an additional requirement, okay? And the additional requirement is that it cause, or the individual or entity reasonably believe it has caused or will cause, identity theft or other fraud to any resident of the Commonwealth. So in other words, it's not enough for someone to have acquired the data. There has to be some further risk of harm here, or some indication, for example, that some harm has already occurred. As I said before, a lot of these laws are targeted at identity theft and other forms of fraud. And the idea here is that the notification requirement itself won't apply unless you think the circumstances are such that, in fact, there's some reasonable risk of either identity theft or fraud, right? And so that's essentially what these kinds of parts of the provisions do, under Virginia law. Then, if the information, even that's acquired in an unauthorized way, if indeed it hasn't caused, and we don't reasonably think it would cause identity theft or other fraud, in Virginia anyway, according to this law, then in fact there's no duty to notify under Virginia law. Similarly, Colorado, for example, provides that notice is required unless an investigation that the entity itself is required to perform determines that the misuse of information has not occurred, it is not reasonably likely to occur, right? So again, is requiring some sort of assessment of the risk, but assuming the risk is low, then and hasn't come about yet, then here too there's potentially no duty to notify. And so here's where it's possible, for example, that the folks at Uber could potentially have been thinking in these terms, right? I mean, the way the Uber incident was treated there was treated as a kind of part of the bug bounty program. This idea that, well, now this vulnerability has been disclosed to the company, it's now been patched. All the data that had been acquired in this unauthorized manner had been deleted and destroyed, right? And so the idea potentially is that, well, going forward, there's no further problem. And since there's no further problem, no further possibility now that this data, at least, coming from this particular hacker, will in fact be misused, and no indication that this hacker indeed misused any of the data before contacting Uber and before ultimately taking payment and then having the data destroyed, then arguably under those kinds of laws, perhaps then Uber was not required to notify anyone, exactly because there was little or no further risk of identity theft or fraud. And maybe in this regard, the fact that its driver's license numbers in particular might also matter, at least if that's the main focus of what was in those accounts. It's not entirely clear from the reporting whether or not there might have been more in some of these accounts. But assuming we focus just on the driver's license numbers themselves, then maybe, particularly having only had that, if that's the case, that also tends to minimize the risk of future fraud or identity theft. But as I pointed out initially, that's not the definition in New York, right? In New York, all that's required is some sort of unauthorized acquisition. Here, the data was clearly acquired by the hacker. Indeed, that's exactly what Uber wanted to have deleted. So in New York, for example, there's no further requirement that there be some sort of risk of further harm or something of the like in order to trigger the notification requirement. And New York's not alone in this. There are several other states also that similarly don't necessarily excuse the notification if there's no risk of harm. So in these kinds of scenarios, even if on the one hand, Uber may have sort of thought of themselves as being okay exactly because it didn't seem like there was going to be further problems, the law is largely not written that way, which is interesting because, of course, it's then caused some companies to try to think about, well, how are they dealing with these kinds of bug bounties generally, right? And in what sense might there be a further disclosure requirements, even with respect to bugs that are found within the context of these kinds of bug bounty programs, where they go out and try to get other people to find vulnerabilities, disclose them to the company so that they can then fix them. As I said, laws like New York don't seem to look for some future harm. All right, so those are the kinds of situations that then potentially require disclosure. Assuming you're in one of those situations, what do you do? And so now just a few, basic facts about what it is that you have to do if you're in the situation of needing to disclose one of these data breaches. So first, when do you have to provide the notice? New York says in the most expedient time possible and without unreasonable delay. Also noting, consistent with the legitimate needs of law enforcement or any measures necessary to determine the scope of the breach and restore the reasonable integrity of the system. So in other words, sort of responsive measures that the company itself might take. And that, that kind of language is pretty common among the various states of saying that you can have some delay in order to provide for whatever law enforcement needs. So, for example, if you're trying to track down the person, right, who engaged in the hacking activity, you may not want to disclose the fact that you know about the hacking activity until you've finished being able to try to track down who it is that ultimately was the one engaged in the hacking activity. So that's an example of like legitimate needs of law enforcement, or at least in some instances, you may also not want to disclose until you have an opportunity to assess exactly what has happened and to be able to try to plug the holes, right? So certainly, for example, if it involves some sort of breach that's because of some kind of software error or something along those lines, you want to make sure that you've patched that, obviously, before you go about disclosing the existence of that hole. Okay, but New York otherwise doesn't specify, with any kind of precision exactly what kind of period is required. Some other states do, though. So here's Florida, for example, which says no later than 30 days after the determination of a breach or reason to believe a breach occurred. Again, unless subject to delay or waiver, those are provisions. The delay here is again for things like law enforcement, and the waiver in Florida's case is again in situations in which there's no risk of future or minimal risk of future harm. So, but Florida actually specifies this idea of a 30-day window within which to disclose. And if you do need to disclose to, who do you have to disclose it to? So in general, the primary target of the disclosure are the affected individuals themselves, but I think most states provide also for notice to the state attorney general and or other state agencies, so that the government can also keep track of these kinds of data breaches. And many states also further provide for notice, particularly of large breaches, to the consumer reporting agencies. That also is a kind of fraud prevention measure, right, to be able to help to flag these kinds of issues ahead of time in case then there ends up being some form of identity theft or the like. Next, what kind of notice do you need to provide? Here's New York's rule. So this is how you go about actually notifying the individuals involved. It could be written notice, electronic notice, telephone notice. There's some conditions on all of these kinds of things, but most of the time, the way this happens is through some kind of letter and or email or something of that sort. But New York, like many other states, also provides for the possibility of what's called substitute notice, the ability to provide notice by using some kind of mass media or the like. Usually, as you see here, the substitute notice requires you to email people when you can, but then allows you to use things like your website and major statewide media as the way that you go about notifying people. And this is, as it says, if the scale of the notice was otherwise going to need to be large enough, or if you don't have sufficient contact information, because it certainly could be the case that you end up not actually having the contact information to be able to give individualized notice in some instances. Lastly, what happens to you if you fail to do what you're required to do under these data breach notification laws? The primary means for enforcement under most of these laws is some sort of action brought by the state attorneys general. That's the kind of essentially state law enforcement, essentially. And that's a lot of what we're seeing now in the Uber scenario. So in fact, the Pennsylvania Attorney General just filed something earlier this week to basically enforce their data breach notification law against Uber. Some of the states, though certainly not all of them, and it's sort of like somewhere around 16, I believe, somewhere around there, of states provide for a private cause of action, meaning that the individual consumers themselves can sue. There's usually various kinds of restrictions on when exactly that can occur, but at least some states provide for the possibility that the individual consumers themselves can potentially sue. And in this context, what can you obtain? Well, there's usually some provision for some kind of either civil fines or other forms of obtaining damages from the company that failed to notify. And the amount of the fines varies widely. There's, it's all over the place in terms of the how much each state ends up providing for. But, when you add them up, particularly across the various states and across all the people affected, right, these fines are often set up as a, per person or per account basis, though some states also cap the total from any one incident. You can add up to quite a bit. It appears, for example, that in this Pennsylvania thing, that the top possible fine here could be $13.5 million. So I don't think anyone thinks that in the end that will necessarily be the number, but it at least shows the potential for exposure to very large fines at a minimum, if not necessarily to damage lawsuits brought by the individuals in situations in which companies fail to disclose, right? So this is, this is serious business for these companies, and companies in general, whether they're like Uber or not, very much need to have these kinds of data breach notification laws in mind when things happen. So with that, I'm going to turn for a moment here and just talk a little bit about our new masters in data and privacy law. If you think a little bit about what happened in the Uber case, right, with this security team that obtained this information from the hacker, that ultimately they thought they had more or less handled, but which it turns out had the potential to trigger various kinds of legal obligations. I think it's in some ways a prime example of where the legal requirements around data and privacy very much affect people beyond the people who are actually lawyers at these particular companies and other institutions. And it shows the ways in which folks like tech teams, among others, but also just business people generally, really can use some basic knowledge and insight into how the law works, into what's required. Not obviously, there's no way to necessarily obtain enough information in order to be able to just do the law yourself. That's probably not the idea, but potentially enough to know when to consult a lawyer in order to find out more, right? Obviously, there's, as I described, 48 different data breach notification laws. People who aren't lawyers aren't going to necessarily know anything about exactly what all of them require, right? That you're going to have to go to consult with a lawyer with. But on the other hand, people who are dealing with this stuff need to know like what kinds of things might actually, trigger these kinds of requirements, and when might you want to at least go ask a lawyer about whether or not something more needs to be done. And in a way, that's the kind of picture that we have for our Masters of Studies in Law. This is a program aimed at non-lawyers, non-lawyers who deal with data one way or another, right? Whether they're more on the tech side or more on the business side or in areas like compliance or the like, but for whom it would be extremely helpful in the work that they do to be able to understand a bit more about the legal requirements around data and privacy. And so this is designed not only for people in things like tech and compliance and business, but also others dealing with these at a regulatory level in any way, as well as those who are dealing in the litigation context. So that's the kind of e-discovery context as well. The program is 30 credits. It's designed to be able to be completed in 1 year if you do it on a full-time basis, but it's also possible to do it on a part-time basis as well. And it's a fully online program designed to be the kind of thing that's flexible for the people who are involved. So if you want to find out more, the slide here has a couple places where you can go to find out more and to apply to the program.